versus James-Varnell, Oregon. As you approach, first of all, welcome. Thank you for coming here today. Appreciate it very much. When you approach the microphone, I'm going to ask that you begin by stating your name and the party you represent so that the audio and video recording will be easier to track when and if anyone goes back and watches it. We'll hear first from counsel for the appellant, the state of Texas.
May it please the court. My name is Emily Johnson-Liu, arguing on behalf of the State Prosecuting Attorney's Office in this case arising from Waller County. Everyone agrees that it isn't a Fourth Amendment search for a drug dog to sniff around the air around the outside of a vehicle. The Court of Appeals held that it became a search because of one difference. The drug dog stuck his nose through the open car window. The court did so based upon United States versus Jones, which brought back the common law trespass theory of searches. But the court is wrong for two independent reasons. Under Jones, first, that act of the drug dog's nose going through the open window wasn't a trespass. And second, any trespass that occurred wasn't the intended means of obtaining information.
Counsel, if the theory is the dog is a tool of law enforcement, why is the dog's nose going into the car different than, say, putting a GPS tracker inside the car?
For the second reason, primarily, because it is to be a search, one integral thing, it needs to be something that was the intended way that this happened, that this played out. And Jones...
Didn't the law enforcement intend the dog to do a search?
They intended to bring the dog on the scene. They intended the dog to go around the outside and sniff the air around the outside. And it was the dog's, being a dog, the own instinctual acts of the dog that made the dog put his nose through the open window.
How are we supposed to distinguish, though, between the dog being a dog and the dog being a tool?
Because it's more than... To be a search, it requires more than just that there have this intent that there be a search performed looking for information, as police are always doing, plus the causation, sort of but-for cause, you got some information. These things have to conjoin together so that you have one thing that can be called a search. And I think in the seizure context, this is brought more to bear. In the list of authorities that I filed on Monday, it arises in the seizure context instead of the search. But there it involved officers that are pursuing a car with a high-speed chase, so lights and sirens on. And they are wanting the person to be pulled over. They want a seizure to occur, and the officers lose control of the car at the high speed, and they crash into the defendant's car, stopping him. That was not enough to be a seizure, even though you had both a desire for a seizure to occur and the causality of a stop happened. It has to be more than that. It has to be...
They did bring the dog for the purpose of identifying the potential presence of illicit substances, right?
But they did not bring the dog so that a trespass would occur.
Let me ask you this, as your side of the case here, the state, if I go quail hunting, if I go out for a walk this spring with a dog who points at quail, bites them and seizes them, if my intention was not to go hunting, can I still not be cited for out of season or unlicensed hunting? I mean, the idea that the dog is going to do what a dog does, who's accountable for that?
I think yes, that you as the hunter, as the owner of the dog, are going to be liable.
But a different rule applies to the state when the state brings a dog to a scene where its purpose was to investigate the potential presence of drugs.
Because we're asking, did a Fourth Amendment search happen? And that has to be more than just it's a different context.
Counsel, did the officer make any effort to stop the dog from repeatedly putting the nose in the car?
Yes,
And that effort was to pull on the leash,
that's right.
which is how the officer makes the dog sit, which is how the dog indicates the presence of drugs. And this drug, Etozalam, is a prescription drug which dogs are not trained to sense for.
He was not trained on this particular drug, that's correct. The officer, as I understand the testimony, is leading the dog to continue around the outside of the vehicle. And the dog is coming back on its own and leaping up onto the car and sticking its nose into the vehicle.
But the dog doing that isn't supposed to be an indicator that the dog's alerting, right?
No, the dog, the ultimate final indication is passive with him sitting down in front of the vehicle. So that's when the dog is communicating the information that he senses.
So it's really up to the officer to determine when there's an alert that has occurred, to interpret the dog's actions.
That's right. And that's why they go through multiple weeks of training so that communication is able to happen.
I guess one of the problems, I mean, there's so many possible questions with this case, but is it possible that the dog smelled the bad food in the car that was spoiled?
Yes,
That totally fooled him and he just thought there was something he could eat?
it's possible, yes.
So then how do you distinguish between the drugs and the rotten food that any dog would eat?
Well,
Is-
so I think the reliability question is something different, and that was raised in this case and could be an issue if the court remands it back to the Court of Appeals. But if the dog is smelling and reacting to the presence of the food, to me, that sort of indicates this is not anyone intending to make the trespass happen so that we can obtain
dog being a
information.
dog, right?
It's the dog being a dog.
So how are we supposed to fashion a test to distinguish between a dog being a dog and a dog being a tool?
Well, because I think the federal circuit courts have already done that. They've said, have the officers opened the doors and windows? Have they brought the dog? Are they leading the dog with the leash to a particular place? All of these things go to show, are they orchestrating the trespass? Are they trying to make this happen so they can find greater information? And if not, if you have testimony like we had, that sticking your head up by the window, behavior like that is not conditioned.
All those things are like, that's still not gonna stop a police officer from being like, well, we're not gonna do anything, but we just really hope that dog's like, "Arr!" and just jumps up on the car. And they're like, look, we got it, it's not a search, we got an indicator that the dog is interested in what's inside the car, so that they can say that this is valid search, or that this is not a search, this is not a trespass, so they get into the car without actually having to get into the car.
If it's truly instinctual, I think it's hard to make the dog do that. And so certainly if this court wants to go in the other direction and say, hey, we're gonna make a hard and fast rule, we're gonna train dogs never to jump, never to get in close, but sort of
The rule wouldn't be to train dogs not to jump or get close. The rule would be like if something penetrates the inside of the car, that's a search, that's an intrusion, that's a trespass. Wouldn't that be the hard and fast rule?
in order to prevent that from happening, I think the officers are gonna pull back. The
Counsel,
training will be that you
Driver
can't
and
do it.
occupant were out of the vehicle at the time, correct?
Yes,
If the dog had jumped through the window into the car, would you still say this was a legal search?
I think that's more likely to be a trespass.
Then how much of the dog is relevant? Half the dog? Just the operative nose? What part of the dog is relevant here?
So my line would be, is the dog touching the car at the very least? We don't have that here, so that's why it's not a trespass. If
The dog has his paws on the car and his face in the car. You represent to the court he's not touching the car?
So at the trial court level, the only issue that the defense raised was the nose going through the open window. There was never a point at which they're saying it's the dog jumping up on the car that makes it a trespass. They're saying merely crossing that invisible plane through the open window is the trespass. Because they relied on that, that's what the trial court findings are relying on, that's what the Court of Appeals relied on, that's why it's
So as long
here.
as the dog's nose goes in, but the scruff of its neck doesn't actually touch the car, that's fine.
It is, It is not a common law trespass if there is not even touching. Now, if there is contact, if the question would be, is this intermeddling? And that's where the Idaho State Court of Appeals was focusing on that being intermeddling. But to be a common law trespass actionable, there had to be damage alongside of the touching. So that we're not into these, like, is it just the, tiny little bits of touching. And the whole purpose of this common law trespass was that our interests, property interests, are different than they are with land. It mostly has to do with our interest in being able to use and possess that property. And if the intrusion that happens, the dog nose sticking through the window, doesn't impose on those interests, then it's not a common law trespass. It's something that other people could do without violating property rights, so why can't officers do that?
Back to Jones, though. Like, Jones, was there any damage to the vehicle by putting the GPS tracker inside the vehicle?
There was not, but Jones is pretty dramatic. I mean, Jones is essentially transforming the defendant's car into a personal tracking device of the defendant. They get to know everywhere that person goes as a result of attaching something physically to the underside of the vehicle and monitoring it.
Right, but that's different. That's an expectation of privacy issue with regard to the volume of stuff that you're getting from that. That's not the same thing as I'm talking about, which is you're saying a common law trespass has to require some sort of penetration into the vehicle and some sort of damage. And the point in Jones was there wasn't any damage. They just simply broke the plane by putting that GPS tracking under the car, in the car.
And you're saying common law, you want to represent to the court that common law trespass requires touching. Is that correct? Do I understand you?
No. So let me try to answer both of those. So there are multiple ways that you could have a trespass. One is by dispossessing it. You could cause a cattle from someone else's land to run off of the property. You're not actually touching it, but you were dispossessing the person of their personal property. That's one way. You can do it by using the.
I'm talking about entry. Are you saying that it requires touching?
The problem is that there isn't really a mere entry as to
So then
personal
law enforcement
property.
could equip a drone with a camera, fly it onto your property, space all through your property, and if you had an open window, they could fly into that too. By analogy, in this case, law enforcement could take that drone and fly it partly into the car.
But you're making a distinction between real property and personal property.
Correct, as the law always has. So as to the land is absolutely inviolable in that sort of, these sort of magical lines. So a finger over the line when it comes to land, that is a trespass and you're golden. So that would violate, it would be a
So
Fourth
you're
Amendment.
limiting the touching to the vehicle space.
So it would be for personal property. So hovering over someone's personal property isn't considered a trespass.
So it's not a trespass if the officer sticks his head in there and is trying to sniff around.
It wouldn't be a trespass. Would you have a reasonable expectation of privacy? Yes.
What if he takes his body cam and reaches his hand into his body cam to?
Same thing. Same thing. You wouldn't have a trespass. You would have a violation of your privacy interests under CAPS.
You're saying that the officer, whether by virtue of the body cam or the dog, can break the plane with some sensory object without it being a trespass?
Yes. That
You don't find that to be a slippery slope?
No, because if you have we do have two tests. We have the CATS test for reasonable expectation of privacy, and we have the property-based common law trespass test under Jones.
Let me make sure I'm understanding where you're going here. The officer sticking part of his nose or his hand inside the imaginary plane of the window frame of the vehicle, not common law trespass,
Right.
but nevertheless invasion of privacy
Yes.
for purposes of, what if it's a convertible?
That is much harder because could already, unless
Well,
it
your
puts him in a
expectation-
vantage point where
Your
you,
expectation is not as great in a convertible.
absolutely
The top
not
is
as-
down,
that's right.
How reasonable is that expectation of privacy?
I mean, maybe you are to some degree under the seats or something that are
How
not.
reasonable is the expectation of privacy if the window is open?
It is lower because when the window is open, you have a lower
What if
expectation
the
of
officer
privacy.
directs, under color of authority, the driver or passenger to lower the window, as in this case?
The timing of that is going to matter. When they lowered it, it's like within 2 or 3 seconds of the interaction between the officer, way before anyone's ever contemplating a drug dog being on the scene. So I don't think that's a factor in this case. If you were much closer, you already have the drug dog there, and you're saying, let's roll down all the windows and make that happen, then I think you are into that sort of facilitation or
As long as the
orchestration.
officer tells them to roll the windows down before the dog gets there, it's okay?
Do we find it as part of the facilitation of this trespass?
Is there any evidence that the officer ordered the window to remain down after they left the vehicle?
No.
Okay. Counsel, I believe you have a few minutes for rebuttal. Let's hear from the appellee, please.
May it please the court, Parker Rider-Longmaid for Defendant Appellee, Courtney James-Varnell, Oregon. As my friend said, this case comes from Waller County. I want to start with the trespass questions and then move on to the instinctive impulse questions, which I think are the harder questions in this case. On the trespass issue, Jones resolves this case because what Jones says is if you have mere physical touching, you have a GPS device simply placed on the undercarriage of a Jeep, that's a trespass. We have touching, as your honors have noted from the videos, you can see Deputy Kern testifies that Jax touched the car. There is that contact. The state has raised the touching of the car as well. The court can watch the video and see this happen. So there is that touching. Then there's also the nose intrusion.
Let me just ask this. Most of the drug sniffing dogs, when they sense something that's from the outside of the vehicle, they go around the vehicle. And the windows may very well be up, and they can still smell the drugs inside of the car. So where's the harm if the window's down anyway, or if they stick their nose in?
Well, Your Honor,
How are you going to distinguish that when your prime witness, the dog, can't say when he smelled it?
I want to say two things, one about the facts of this case and then one about the way the tests work, because of course the physical intrusion test that the Supreme Court announced in Jones and Jardines is really a sea change, as the Fifth Circuit has called it in the law, and it matters whether there's a physical intrusion that is conjoined with the purpose of obtaining information. On the facts of this case, if you look at the clerk's record at page 147, these are the findings of fact of the trial court. They say that there is sufficient credible testimony establishing proof beyond a reasonable doubt that prior to Jax's nose intruding into the interior of defendant's vehicle, the dog had not alerted to the presence of contraband. So at that point, there is no probable cause. There's no argument that there's probable cause before Jax makes contact with the vehicle and then sticks his nose into it repeatedly. So it's different from a case where, let's say perhaps the windows were open and the dog alerts because of something is smelling outside of the car without having made contact with the car, without sticking his nose into the car. That's a different case. And in fact, just to move over to the instinctive impulse cases, some of those cases, if you look at, those are all reasonable expectation of privacy cases, which is a key point. They're all decided either before Jones and Jardines and apparently without knowledge or consideration of Jones or Jardines. But in addition, some of those cases also involve alerts before the dog put his paws on or intruded into the car, which means if you're looking at like a slippery slope type of question, are we going to have a different result in these cases when we apply this new test that the Supreme Court has articulated? Not in many of them, for the exact reason that Your Honor suggests. But on the facts of this case, which are what matter, right, we don't have an alert or any indication of probable cause until there is the intrusion into the car.
Started or had the dog gone around the vehicle prior to putting his nose in the vehicle? In other words, ultimately, would he have not smelled the dog, regardless of whether or not he stuck his nose in the window or the car?
Well, I don't think, Your Honor, the dog actually did smell anything the dog was trained to alert to, as we've been discussing. The dog was trained on marijuana, heroin, cocaine, MDMA, and meth, and it alerted allegedly to a tizalam, right? Or maybe to the seafood or the Chinese food that was in the car, as far as they knew. If you watch the video, the dash cam, which is SX1, or Deputy Kern's body cam, which is SX7, you can see the dog first go around as being handled by Deputy Kern, and then put his paws up on the left side of the vehicle from where we're watching. They go around to the right side where the passenger side window is down, and the dog leaps up 3 different times and puts its nose through. And if you want to look at the actual facts of the case, and even if you were applying a facilitation type test, which we think is not consistent with Jones and Jardines and the Idaho Supreme Court in 3 different opinions, it spilled a lot of ink on this issue, and I'd urge the court to look at those opinions. I think they're very helpful. But each time this happens, Deputy Kern is handling this dog. So if we go to the instinctive impulse test and whether there is a purpose of obtaining information conjoined with the trespass, absolutely. The entire time the officers have the purpose of obtaining information, and not just generally obtaining information, but of obtaining information about this car through the mechanism of a dog sniff. The entire time, Deputy Kern is handling this dog. And when he's doing it, the dog sticks his nose into the car while putting his paws up on the windowsill. And and again, I think Jones resolves the questions about trespass because Jones says, you know, a touch is enough. Justice Alito in his concurrence says, you know, any violation of the inviolable dignity of property, this is the test the court is using. And he disagrees for that reason. He doesn't think this should be the test.
Why shouldn't we look for an analog for common law trespass in this situation?
I don't think the court should look for an analog for the exact reason that I think Jones has resolved. And also, I just point out that on page 410, Jones points out that in the New York versus Class decision where the officer reached into the car, that was an intrusion as well. There's also the Maryland decision in Grant versus State where the officer sticks his head into the car, and these are all clearly trespasses. But if you do look at the methodology that Jones is using, it's looking at the King's Bench case in Entick versus Carrington, right? The seminal case where 4 messengers from the king go in, they think they have a warrant, they go ransack someone's property. The court is applying this precedent, which is primarily a home real property case, and saying this is the rule for all this property. Why? There were differences at common law, you know, specific pleading differences for chattels and that kind of thing. But what the court makes clear in Jones is you're not looking for 18th century analogs. You're really looking at what understanding did the founders have. And I think with the state's position here shortchanges this constitutional purpose. In the Fourth Amendment, the founders put in persons, papers, homes, and effects. And these are effects. So they're saying this kind of property gets protection also from intrusion. And some of the arguments...
Do some of those things like effects, it's harder to say that they have the same protection as a home, right?
Well, I would put it this way, Your Honor, because what I think the state is saying, if I understand them correctly, is you may not be able to bring a cause of action for damages if you don't actually have actual damage to the property or this kind of thing. But what is clear, and I would point the court to the Idaho Supreme Court's decision in Dorff, because this is about contact. You have a right of self-help, always. You always have the right of self-help. You have the right of self-help now under most states' laws. You can tell someone, get off my property, my chattel property. You can't touch it, it's mine. That shows you that you have this right in this property. It's not about whether there's a cause of action you can bring in a particular state court for damages. That's not the question in 1791. So what they're asking is, do you have these property rights? Do we want to protect those property rights from invasion by the government? And that's what the court is saying. So
there are quite a few Federal Circuit opinions on this. Which of them do you think is most helpful? I think there's at least half a dozen various circuit level opinions on the question of whether the dog injecting itself inside, crossing the plane of the vehicle. I believe it's the Sixth Circuit that said unless there's evidence that the handler prompted the dog to go there, there's no search.
So I think, Your Honor, there are the dog sniff cases that you mentioned from the Federal Circuits. There are also recent cases after Jones and Jardines about what a trespass is. And some of those cases are very helpful because we know that there's a search, for example, when an officer taps on a tire.
Which do you think is best for you?
I would ask the court to look at, for example, the Richmond case from the Fifth Circuit, which looks at just tapping a tire is enough, or the Taylor versus City of Saginaw case from the Sixth Circuit, tire chalking is enough for a search, right? These are after the Jones and Jardines decisions, and then there's also a Ninth Circuit decision in Dixon where inserting a key into a car to see if that car belonged to the key was also a search. And these cases don't necessarily find that there's an unconstitutional search for different reasons. The Sixth Circuit leaves that possibility open, but it just depends on the particular nature of the search.
What about the recent case of State v. Oregon from the Fifth Circuit?
Is that Richmond, Your Honor?
No, State v. Oregon. Excuse me, I apologize. I'm giving you the wrong side. That's United States versus Keller from the Fifth Circuit.
I'm not sure I know the facts of that case.
Basically, the court held that a mere physical touching, such as when an officer leans on the door of a car while questioning its driver, is not a search. And it went on to say that the instinctive actions of a trained canine, including placing his paws on a vehicle's exterior, constitute an incidental contact, not an unconstitutional Fourth Amendment search. And that's a recent case out of the Fifth Circuit.
So, Your Honor, I want to respond to the officer leaning on the car and then also to the instinctive impulse cases, because it sounds like this decision is like many of the others that Your Honor was asking about as well. So in terms, you have to have, of course, the purpose of obtaining information by intrusion conjoined with the intrusion itself. And I don't think that's happening in most cases. You have to look at the exact facts of the case when an officer is just leaning on a car. I mean, for one thing, the officer might be leaning on a car and just asking the driver questions. Maybe it's a reasonable suspicion or probable cause of a traffic violation type of stop. And they're at, where are you going? You know, where have you been? This kind of thing that officers tend to ask people when they make a traffic stop. There's not a purpose of obtaining information about the vehicle or the inside of the vehicle when they're just those questions. So I don't think you have to go to ask, is this a trespass, you know, because of the nature of the touching. You just don't have the conjoined purpose at that point. But this is, I think, part of the problem with the instinctive impulse cases, because as we were discussing earlier, when the officers bring a dog to the scene, and let me give you a hypothetical where I think it might be harder. Okay, let's say Deputy Kern in this case had started to get Jax out of the car. He trips on a stone or rock that's there. Jax bolts out. He's not on a leash. He goes and does what he does. He jumps into the car, whatever the facts are. I think at that point, it's a much harder case, because you say, well, does law enforcement at that moment have the purpose to obtain information from the car by means of the dog that is the tool of law enforcement? I think there's an argument there that no, they don't, because really Deputy Kern's purpose at that moment is to, you know, regain control of Jax and, you know, get up, make sure he's not hurt, whatever the purpose may be. But the entire time in a case like this, and like many of these cases, and this is why I think the Idaho Supreme Court says the instinctive impulse test is just not compatible with Jones and Jardines when they're looking at afterwards, is that you have the law enforcement officer handling the canine the entire time. The purpose of handling the canine is to obtain information about the car, what's inside the car. And then you have this trespass, but what we also know, I mean, if you want to talk about trespass at common law, you have Blackston saying, if a cattle or dogs, you're responsible for their trespasses, to this earlier question.
But that's very effective, and I'm very impressed. But to take it back to Judge Parker's question, is your answer that's just crazy talk from New Orleans? I mean,
Well,
the idea that
we never say that, Your Honor, but
you're free to do it if you want. But the officer sticks his head into the vehicle, and the Fifth Circuit says it's not a search.
I'm not aware of a case where an officer sticks his head in the vehicle and says it's not a search. I would point out that I'm not entirely sure of the state's position in response to Your Honor's questions, because I think it sounds like there may be a privacy interest violation that the state is conceding in those cases when the dog or the officer does something. But in any event, all of these decisions about impulse from the federal courts of appeals that I'm aware of and that are discussed in the briefing, all but 2 of them are before Jones and Jardines. I don't think any of them engage with Jones and Jardines. In other words, they're all reasonable expectation of privacy cases. So whatever conclusion they come to, it really doesn't have a bearing on what we're talking about with the physical intrusion test with Jones and Jardines and what you have to look at. Do you have this purpose of obtaining information? We've discussed that. Is it conjoined with the trespass that occurs? And it is. And so the other, I mean, there are also major administrability problems with this line of thinking. Because how do you know what is in a dog's mind? Why should you be asking what's in a dog's mind? All over the
Counsel, let me address that. We now have drug sensing technology. You go through it at the airport when you get into the booth and get hit with the blast.
I did.
Assume that an officer has a portable drug sensing technology and he sticks the wand in the open window. Is there any meaningful distinction between that and what we have in this case?
I don't know that there is, Your Honor. I think the intrusion is the problem, and it's conjoined with the purpose to gather information. This is not a Cabela's type of case, or where the dog is outside, and because the Supreme Court's reasoning in those cases, right, which, dubious though it may be, is that the dog is not actually invading a reasonable expectation of privacy because you have no reasonable expectation of privacy in contraband, and the only thing a dog can detect is contraband. I think, for what it's worth, that these devices at the airport, I'm no expert in them, but the devices at the airport are probably more like the thermal imaging cameras in Kylo. I mean, probably many people are uncomfortable going through those devices because of what the TSA officers can see. So there may be also a very clear violation of the reasonable expectation of privacy in that circumstance.
Let me ask you this question. The dog actually jumped up on that door 3 times, correctly?
That's right.
Okay, and the officer has a hold of the leash. So if you're an officer and you have hold of the leash the first time the dog jumps up there and gets a little close, you know, you should be a little concerned at that point as an officer, correct?
I think so, Your Honor.
But he allowed the dog to do it 2 more times. It looks to me like there's some intent on the handler that he actually had intent to get that dog as close as he could to smell whatever's inside the car.
I think you're right, Your Honor, and I think that's why this case is an easy case. I would just say the whole point of this trespass theory is to keep easy cases easy.
Where in the record does it show that that was the intent of the officer? I think the record is contrary to that, and from what I read from the officer's testimony. So the officer intended for the dog to put his nose in the car and his paws on the car. I think the testimony is contrary to what you just said. Am I wrong?
No, Your Honor, to be clear, I'm not making a representation about the officer's intent. I'm saying that you have the elements of the Jones and Jardines test satisfied because you have a purpose to obtain information by means of the dog sniff, and then you have a trespass through the intrusion that is the dog sniff. I actually think this is part of the problem, is trying to ask what the officer's intent is. In any event, if you were going to ask those questions, you'd have to be asking those questions under the objective reasonableness paradigm that governs most Fourth Amendment tests. In fact, in the Torres versus Madrid case procedures as well, they make this point clear. They make the point clear in Jardines as well. I think it's at page 10. So it has to be an objective reasonableness test. What is the officer's behavior manifesting? I think what we know the officer's behavior is manifesting is this purpose of obtaining information through the dog sniff. But I think that this goes to the point of, I think probably the illogic as a matter of law of the state's position. And part of it is, we know dogs do these impulsive things, therefore we just have to let them do them. We can't do anything about it. Well, but if you know the dogs do this and you foresee it, you have knowledge or at least recklessness as to whether it's going to happen. And in this case, it shows you exactly that, right? And I think Justice Brody in the Idaho Supreme Court opinions really takes this on, including in the Randall case, and says, you have to be able to train these dogs not to do this. And if you can't use them the way that you're using them. So you know that the dogs, there's a high likelihood the dog's going to do this. And I think in this case, if you can watch the video at SX7, I mean, SX7, which is Deputy Kern's body cam, I think starting in about 12 minutes, if you watch from there, or SX1, which is a dash cam starting in about 28.5 minutes, and you can watch what happens. But I think it's exactly the point that this happens multiple times. Now, obviously, we don't have what happens in other cases, but the point is it's not being stopped. And again, it just goes back to the way that this test should work. It's concerning to think about setting up a test where there is no incentive for the officers to make sure the dogs are trained so that they don't make these physical intrusions.
When you look at the breaking of the clothes, which is what we've been talking about, just from a common sense perspective, let's say somebody comes up to my car and my window is down and they put their hand on my car or on my car seal, or they lean their head in to talk to me. Are they trespassing? I don't think any of us would conclude that they are, and this is not unlike that. So, I mean, the law has to be workable and practical. And when I go back to this case I asked you about to start with earlier, United States versus Keller, the court held there, the Fifth Circuit, that the district court did not err in concluding that placing of the paws on the defendant's vehicle was a search, but they went on to say that the intrusive actions of the trained canine constituted incidental contact. And that's what it seems like to me. You've got a dog, you're doing a search, you're saying to these people who are using these dogs, you've got to train this dog to never touch that car, to never, instinctively touch the car, which is what the court talks about here. So that seems like you're talking about how it's a hard standard in the other direction, but don't you think it's just as hard to try to require the police to train these dogs not to get excited and touch the car? I mean, that seems pretty difficult under very stressful, intense situations. How do you implement that kind of a standard?
Well, Your Honor, I think there are a few issues in there, so let me try and take them from the beginning. So on the point about the touching of the car, I think if someone came up to any of our cars and put their hands on it and you were to say to them, hey, please take your hands off my car, I think you have every right to do that. I think it is a trespass in that sense, but it's not something that's, you're not going to go file a lawsuit and expect in an American court these days to be able to recover damages for that. But it doesn't mean you don't have the right to tell someone to take their hands off your car. And then you go back to what the Supreme Court is saying in Jones, and I think it's at 408 Note 5, where Justice Scalia is saying this is not just about a trespass, it's a trespass conjoined with the purpose of obtaining information through that action. And that's exactly what's happening here. So I think if you change the hypothetical to someone's putting their hand, officers don't need to necessarily lean on the car to put their head in it. The dog does, just because of the physical nature of it. But if the officer was doing something, touching your car, putting a hand into it to actually get inside and gather information, I think that would be a problem, just like you said. I mean, otherwise, but I also say, like, to the extent that what the Fifth Circuit is saying is inconsistent with the argument we're making, which is we just disagree with the Fifth Circuit in that respect. But I think in terms of whether it's workable, there will be, I think that the answer to this is really, you're going to have you might call them incidental contacts. I would say the better way to see it, so as not to kind of contravene Jones and Jardines and the strict test there, is just to say you don't have a conjoined purpose to gather information by means of the dog sniff and the intrusion by the dog sniff. So I'm not conceding this, but I'll give you another hypo. Imagine Jax is walking around the car and he's wagging his tail because he's very excited, and the tail hits the bumper a couple times. So again, that happening is not necessarily conjoined with the purpose of obtaining information from the search. So I think a lot of these issues can be dealt with actually through a proper application of the Jones and Jardines test, and not by distorting what Jones and Jardines say about the tests that should be applied in the common law, and then making up these tests about dogs' impulses and taking the focus off. No further questions, we ask the court to affirm.
Mr. Hefti, could you just tell me, are you guys appointed to this case, or remind me where you work? Are you with it?
No, Your Honor. We're retained counsel, firm of Lee Smith, Conrad, and Hefti, and Parker and Hannah are pro bono counsel from Skidmore.
Thank you very much. Appreciate it. Thank you.
Thank you.
So to clarify my argument, when an officer sticks his head into the vehicle, our position is that it wouldn't be a trespass, but it would be a violation of CATS through the expectation of privacy. It's different when a dog does so, because the dog is never going to be able to convey any sort of information, even if he sees things that can't be conveyed over into the officer.
Doesn't the dog convey information by alerting?
The dog does convey information by alerting, but you don't have a reasonable expectation of privacy in the smells that are emitting from your open window of the car. And so that's why it wouldn't be a violation of CAT.
Though the cases aren't very specific, one theme that runs through them is that you can't use just any dog. It has to be a well-trained dog.
That's
Would you
right.
agree?
Yes.
Okay. And that issue was actually raised at the original motion to suppress, correct?
That's right.
Though
That's
it was
right.
raised in the context of detecting cannabis from hemp.
Yes.
But I want to focus on the facts in this case. Law enforcement, I'm not aware of any law enforcement agency in the country that trains dogs to detect prescription medication. And Etazolam is a thienodiazepam. It's a prescription medication. This dog, the record shows, was trained to detect marijuana, MDMA, cocaine, methamphetamine, and heroin. And Etazolam doesn't fall into any of those groups. If this dog alerted and there was none of those 5 things in the car, is that not evidence that this was not a well-trained dog within the way that definition is used for the purposes of drug sensing dogs in the Fourth Amendment context?
No.
Why not?
And because there obviously the officer was saying that he thought he smelled the odor of marijuana if there was even residual.
Actually, didn't he say he smelled what he thought was seafood or Chinese food, and perhaps he may have smelled marijuana?
He said very slight. Marijuana, very slight.
So the officer thought he smelled marijuana, but the dog didn't?
We
Or they
can't
just didn't
ask the
find
dog. We can't ask the dog what was he alerting on.
But no drugs were found in the car other than the prescription drug, Etazolam.
That's right. And also remember that this is something that's not prescribed in the United States. So it's not like Eli Lilly is putting this sort of Etazolam together.
Right, it's a Schedule I drug in the United States. It's prescribed in other countries, but it is a prescription drug.
It is a prescription drug, but whether it is manufactured in standardized facilities is kind of a stretch.
Did the dog testify?
The dog did not testify.
And do you agree that this dog actually jumped up on the door 3 times before he ever alerted? Okay?
That's
And
right.
the officer has a hold of the leash, and I can understand the officer accidentally letting the dog do that the first time and getting close to the window. And then the second time maybe, but third time's a charm. It sounds like the officer was doing his very best to get the dog to alert.
From the officer's testimony and what you can see on the video, the officer each time is trying to get is pulling on the leash to try to get the dog to go around the vehicle. And I think, like Judge Finley's question earlier, they do need to be sure that they're not signaling to the dog. And so you need to give them some sort of freer rein to be able to do their dog thing.
If the officer smelled marijuana, why isn't this an automobile exception case?
Well, because no marijuana was actually found. And the officer says he smelled only very slight marijuana, so it was not enough to be like PC to go into the car. In addition, this court does not have to reach the question of does jumping up on the car constitute a trespass or not. Really, the more narrow issue, which was decided below, was that it's just the nose going into the interior airspace. I briefed the broader issue because we lost in the trial court level, and so Court of Appeals could find right for any reason. And that's why I briefed that, but this court does not need to reach that issue.
Counsel, quick question. Your brief says, even if it was an unreasonable search, it shouldn't require exclusion. Why? Concisely, why?
Certainly under the reason that we have the exclusionary rule is a reason not to, because if it's there to deter officers, if you really have a dog that's acting instinctively, we're not going to be able to deter that sort of
But we
behavior.
prosecute people for damaging or injuring police dogs on the theory that it is a police agent.
Sure.
So, but now the state has one side of it, prosecuting for people for damaging a dog, representing it's a police agent. But now when the dog enters the vehicle, it disavows that it's a police agent and goes back to instinctive behavior.
Well, it is a instrumentality of the police. I'm not saying that it's not, but it's still a dog. So you can't like transform the dog into a human and give it characteristics that where a human looking into the vehicle is seeing things at the search.
It isn't the entire basis of allowing searches based on drug sniffing dogs, the concept that they are so well trained and so reliable that they create the probable cause to search where it would otherwise lack. And if you're undermining their training and their reliability, don't you undermine the basis for the search?
I'm not trying to undermine their reliability. I think dogs have a heightened sense of smell that humans do not, and the state is relying on that. But when the question is this actually a search? Is the purpose not just to find information, but the purpose is to trespass? If a dog is doing that instinctively, then you just don't have that element of the Fourth Amendment met.
Counsel, before you go, I want to ask you one question. Your counsel opposite indicated that there are a lot of circuit level opinions that are adverse to his position, that Jones effected a sea change. What is your understanding of that? What's the best case you have post-Jones out of the federal system?
There are multiple cases post-Jones. I think Sharp is one of them. But even the cases that are before Jones, because even under the CATS test, and if it's a seizure, you have to have that additional element, not just a trespass or use of force, but that it be the means, like you are doing that trespass or that seizure for getting information or trying to affect that seizure. And because both of those elements preceded Jones, then the case law, I think, is still on point, and the facilitation test should still be this court's test.
Thank you. We will now take this matter under submission. I want to thank the counsel for both sides for excellent briefs and excellent presentation. I hope we'll see you again.
All right.
Now stand at recess.
Oh yeah, oh yeah.